So, talking about the Republican Party and the South, I tried to get across this sense that as we move into the late 1860s and as Congress's role in Southern politics becomes more notable, you begin to get a sense of how the politics of America are playing out with Reconstruction in the South, that some of what's being done is tied to the future of the Republican Party as it affects both whites and blacks in the South. But nationally, I would suggest that what we've seen in the South in terms of a sort of waning interest in Reconstruction is a national phenomenon. And what I want to do in this segment is talk a bit about why the waning of interest that we see in terms of Reconstruction begins to happen. And I would start out again going back to sort of this business of Republican politics. If we look at 1868, for instance, and that kind of the heights of radical power, certainly the impeachment of Andrew Johnson is that telling moment, but it's also a moment which shows the fracturing. And it's this fracturing between or among those who would pursue further the interest, the investments in Reconstruction, and those who have their limits, who won't necessarily vote to unseat a sitting president in order to pursue the goals of radical Reconstruction. It's that very fracture that I think begins to evolve into the late 60s and 70s as the Republicans struggle to define themselves beyond Reconstruction. Let me see if I can explain sort of more what I mean. If you think about it, by the early to mid 1870s, and the passage of the very laws, the Ku Klux Klan law, the Enforcement Acts, the Civil Rights Act, the 15th Amendment being ratified, when all that is done, many Republicans began to ask what more is to be done. What's left to do? We have amended the Constitution. We have ended slavery through that means. We have established the citizenship with protections for the rights of citizens. And now, the 15th Amendment, we have given constitutional protections for the rights of voters to ensure that citizens can vote. But then we've passed further legislation that has moved us beyond just the Constitution and beyond just politics, beyond, in fact, just law, to look at sort of socially how the races in terms of citizenship may be considered under the law. And I refer, of course, to the Civil Rights Act. Notions of public accommodation, for instance, that go well beyond mere constitutional protections, that authorize authority for federal intervention in the states over the issue of how someone is accommodated, that their basic civil rights are not threatened in this social climate or social environment. The election of 1872, I think, is quite telling of this fracture that's going on in the Republican Party between or among the groups, especially those who wish to persist in defining and protecting the rights of African Americans, and those who are looking to other issues, who are having their attention drawn away from the South. In this election of 72, and a re-election for Ulysses Grant, who has largely sided with radical positions, we began to see, I think, the emergence of groups in the Republican Party who are divided. And specifically, we use the terms, and they did too to some extent, the stalwarts, or the stalwart Republicans, who wish to adhere to the policies of the sort of radical republicanism of the 1860s. And then you have the emergence of a faction that is more leaning toward other issues like the economy, like corruption, and even thinking about reform of Republican politics, of national politics. In other words, it's an opening, if you will, when Republicans began to think about their own party, when they began to think about the problems that exist in their own regions outside the South, it seems somewhat natural that their attention would be drawn away from the problems of the South and toward their own homes, so to speak, their own cities and towns and rural villages. So it's something I think we see again. Much as there are parallels from 1860 to the 1960s in terms of things like civil rights legislation, I think in the 1960s, especially the late 60s and into the 1970s, you do see in the United States a sort of gradual weariness developing, especially among whites, with the whole idea of civil rights. Now, clearly, we're talking about two different things, and no time in history is exactly like another time. But there's enough there in parallel to suggest that what's going on with Republicans at least has the symptoms of a certain weariness with the campaign on behalf of African Americans, freedmen in the South. A campaign that ultimately, like the civil rights movement in the South in the 1960s, a campaign that sort of turns a mirror on society. A campaign that asks non-Southerners to consider their own relationships in terms of race, their own perceptions culturally. Well, I'd suggested that some of what was pulling Republicans away from previous devotion, say, to congressionally led or Republican-dominated Reconstruction issues was, among other things, scandal. And there are two major scandals, and I'll just sort of mention them, that occurred during the Grant administration, or administrations, that will ultimately cause the Republicans a great deal of difficulty, especially those that support Ulysses Grant. The first is known as the Credit Mobilier scandal, and it involves a construction firm that is associated with the Union Pacific Railroad. This firm, which is owned by the owners of the Union Pacific Railroad, is charging exorbitant fees for work that's done to construct the Union Pacific. Now, if you don't know, the Union Pacific and the Central Pacific are those two railroads that would stretch across the western United States to connect the Pacific coast with the Mississippi Valley. In essence, they unite the continent as nothing really had done before. And we refer to them together as sort of the transcontinental, or a transcontinental rail line. It's the Transcontinental Railroad. And you know the story of Promontory Point and the driving of the last spike and all that. Well, it turns out that officers of the Union Pacific who had created this construction firm were profiting handsomely from their use of federal funds. And the Union Pacific, by the way, had been heavily subsidized by the United States government. Radical Republicans, or more generally Republicans, were far more open to federal subsidies for things like railroads or other internal improvements, as we call them, that would facilitate economic development in the United States. And they had been since before the war, the Civil War, of course, I mean. Well, a congressional investigation reveals that a number of congressmen, major, important congressmen, and members of the Grant administration have been actively involved in this corruption that's been occurring with the Union Pacific. Additionally, there's another scandal that occurs in relation to gold. During the Civil War, in order to deal with the financial issues surrounding paying for the war and keeping the United States economy going, the U.S. Treasury had turned to the printing of paper money, paper currency, known as greenbacks. Now, traditionally, the idea was that any paper currency or notes were to be backed or supported with actual bullion, gold or silver, what we often refer to as specie. This is a valuable mineral of some kind that has a sort of inherent value. Well, the issuance of greenbacks was generally considered not very economically proper, certainly not a good idea for a stable economy, but more important, it was a wartime measure. It was to last a limited time. So, after the war, certainly by the late 1860s, you began to hear calls for reducing and gradually eliminating greenbacks from the American currency because they were not technically backed in any way, except by the good faith and credit of the United States, kind of how our paper currency operates now. At any rate, what this meant for the supplies of gold and silver was basically that as the major elements backing America's currency, gold and silver and other precious minerals would be in high demand. So if you knew that this process was going to go on and you could get in on the sort of early days of the pulling of these greenbacks from circulation, you could stand to make quite a fortune. I mean, the supply of gold and silver is finite, it's sort of limited. So as it becomes more and more precious to circulate and back circulating currency, its price goes up, its value goes up. So, two major financiers, major players in American financial markets and the financial world, involved in railroad construction and the combination of railroads that we see happening through the Gilded Age, as it was called, and which we'll talk about later. Two of these figures, Jay Gould and Jim Fisk, very, very well-known investors and financiers, decided that with a little help, they could manage to corner or take control of vast quantities of gold so that they commanded the market. They could sort of help limit the supply of gold and silver available, but particularly gold. So their plan is going along reasonably well until it comes to the attention of Ulysses Grant. Grant is known for sort of his complacency. He is not a particularly strong or active president. But when he finds out that his own brother-in-law has been tied in with Gould and Fisk in this effort to corner the gold market based on Grant's own policies, his own financial policies, he just can't believe it. He is struck by the corruption and acts very quickly then to release gold from the federal treasury, which effectively undermines the whole scheme because now there's more gold available than there was before. There would be more. It's impossible to see the value of gold rise. Now, whether or not Grant was ever actively involved in the corruption of his own administration, I don't know. But in some sense, it's less important whether he was actively or knowingly involved then what image was left of Grant? And it was an image of a man who, at a minimum, could not oversee, could not, or would not control his own presidential administration. At a minimum, he had made some poor choices about the people who would serve in his cabinet. I suppose there wasn't much he could do about his brother-in-law. But this business of economics tied into these scandals that rock the Grant administration, economics will play a further role in the diminished interest that seems to exist in Reconstruction. Specifically, in 1873, the United States will experience another in a long series of financial panics. This panic of 73 will lead to approximately 5 years of a depressed economy in which business suffers, individuals suffer, unemployment rises. This particularly affects the growing northern United States, the Midwest, which is in the process of an extensive settlement. What we end up with is economically and because of scandal, there are numerous issues to draw away the attention of Republicans who now see their own homes, their own constituents being affected by these issues on a daily basis. And if they want to retain their position politically, they've got to respond. Somehow, if I can maybe put it best this way, somehow what's happening in the South, what's happening with freedmen, seems less important to many Northerners in the United States as they're affected or afflicted by their own problems at home, and politicians have to respond. Meanwhile, there's the Supreme Court to consider. The United States Supreme Court would ultimately be asked to reach decisions about the laws being passed under these Reconstruction governments and federally and state as well. And I would argue that in many ways the Supreme Court somewhat willingly drives the final nail in Reconstruction, at least the theories behind Reconstruction, through a series of decisions that I'd like to talk about briefly now. In 1873, we have the so-called Slaughterhouse Cases. And I want to say that again, Slaughterhouse. And specifically, it had to do with Louisiana and New Orleans and a question of monopoly. Not the game, right? Not the game monopoly, but specifically the ability of New Orleans to designate certain rendering or butcher shops dealing with the preparation of meat and giving them advantages over other butchers in the city. The Louisiana legislature had passed just such a law, and rival butchers who were not part of the monopoly, who were unwilling to go to a central site and practice their craft, they went to court, shall we say, over this, suing because they argued that their basic 14th Amendment rights, their rights as citizens to pursue their own livelihoods, had been violated. That the state had intervened in the economy in such a way to deny them what was theirs by right as citizens, the right to make a living. The Supreme Court showed in this decision, the Slaughterhouse Cases decision, in 1873, that their interpretation of these amendments that had been passed would be extraordinarily narrow. In other words, their interpretation of the Constitution would be strict. And so looking at this, their argument is that federal powers would extend only to those privileges originating from the federal government. In other words, unless the authority for a claim to right was a federally granted authority through the U.S. Constitution, a matter for the United States government to be involved in, then really you could not argue that under the Constitution your rights had been violated. For instance, if it was a matter for the states. Here's the thing. This issue of monopoly, because it was a grant made by Louisiana for New Orleans butchers, did not meet the test of becoming a federal issue. And thus, if I'm not making too much of a hash of this, thus, the Constitution in this case didn't necessarily or didn't apply. Now, think about it. It may not make much sense yet, but let me say this and maybe it will. If you think about this thoroughly, you begin to get the idea that the court, in emphasizing what we usually call federalism, which is the divided powers of our political system here in the United States, some federal, some state, but identified as belonging to one or another, that the Supreme Court here is going to, when it comes to the 14th Amendment, say, is going to think specifically about whether an action falls under a federal question or a state question. And once the court's done that, issues of civil rights generally, which can't be explicitly shown to be federal in nature, well, they fall under that state category. And that opens just this huge gap in how the 14th Amendment can be interpreted. The Supreme Court has left open the door for all sorts of actions that really, under the 14th Amendment might have been prohibited had they read the Constitution broadly there. But because they don't, many actions that may be committed against freedmen, for instance, so long as they meet the standard of being state matters rather than federal, are now actions that people can carry out without fear of sort of legal retribution under the Constitution. Another case that's very important, very quickly, is United States versus Cruikshank. This case goes back to 1876 and to an event known as the Colfax Massacre, which occurs again down in Louisiana. The Colfax Massacre was a really messy affair, and massacre is the proper term. African Americans being attacked by whites, being protected by African American militia, specifically the sort of White League, a sort of shadow government in Colfax. And in the end, as this militia is attacked, they surrender to this white group. And what ensues is an outright massacre. The actual numbers, you have 100 African Americans or freedmen killed versus 3 whites. And you can get from that sort of score, you can get a sense of who had the power here in this situation. But what makes it a massacre in particular is that so many of the African Americans killed, the freedmen killed, are killed after they've surrendered. It's abject murder. Well, the argue ultimately is that it's a question of rights and the invalidation of rights under the Constitution. That Colfax and the events surrounding it had been examples of white Louisianans trying to deny rights to freedmen, again, under the 14th Amendment. And here again, the court takes a very narrow view. They determine that the acts committed surrounding the Colfax Massacre had been committed by, get this, individuals. Well, why is that important? You may be asking. Well, it's important Because if you remember the specific language of the 14th Amendment, I emphasized back when I talked about that, the wording is that no state shall undertake actions to abridge based on, various and sundry conditions. The point being, no state. The emphasis is on state. The court, in this narrow way, is saying, well, it wasn't a state. This wasn't a state initiative, even though these whites are operating in the form of a sort of shadow or secondary government. They're not operating as the official government. They're not the state. They're individuals. It's a mob. Again, a very narrow reading. And then we have United States versus Reese. Again, moving ahead to 1876, the question here becomes the 15th Amendment. It's a voting issue in Kentucky. And the question with the 15th Amendment is, did it ensure everyone the right to the vote? Or did it merely prohibit the states from using as a determinant those factors that were specifically listed in the amendment? Now, what I mean by that is, or what they meant, the court meant, was, you remember the language that I emphasized earlier. You can't be denied the right to vote based on what? Race, color, or previous condition of servitude. And so the court is essentially saying by the mid-1870s, look, if you're not being denied the vote based on race, color, or previous condition of servitude, then the Constitution and this amendment don't apply. We're looking at this very narrowly here. In other words, if you can be denied the right to vote based on what shoes you have on or what you do for a living or whatever else, anything that's not specifically mentioned in the amendment, there's nothing we can do. That's not what the Constitution says. It's very, very narrow. It's a conservative court in many ways. And conservative in part because too much federal power stands to interfere with too much that's going on, not merely in the South, but in the North. This is a North that is expanding in terms of industry and business. There's opportunity. And frankly, there's a good bit of corruption going on. So, would the court wish to really support a broad interpretation of the Constitution? I think not. I think not. By 1883, just to kind of finish this up with the so-called civil rights cases, the court has declared even the Civil Rights Act of 1875, which I talked about earlier, which provides for access to public accommodation. They have declared that to be unconstitutional as an excessive use of authority under the federal government. And so the stage is sort of set, not only for Jim Crow, not only for segregation, but ultimately in the future for the civil rights movement that will grow throughout the 20th century and perhaps culminate, be manifested again in the 1960s.